Your latest Murgitroyd webinar will start in a few moments. For more information on today's panel and our company, visit murgitroyd.com/webinars.
Hello and welcome to our first series of SME Webinars. These webinars are designed to provide practical information on key intellectual property topics such as trademarks and patents, specifically for SME businesses.
Hi there, I'm Wendy Crosby. I am a Director of Patents in Murgitroyd in our Aberdeen office and also the Head of the Design Group in the company. And I'm here today with my fellow director, who's one of our directors in trademarks, Rebecca Dobson, who works in our Southampton office. Hi, Rebecca.
Hi, Wendy. How are you?
Doing fine, like most people, coming towards the end of lockdown, and that's got challenges, obviously, just in our everyday lives. I thought it would be helpful for us to have a think and just have a quick chat about how lockdown has affected, particularly some of our clients who are in the small, medium enterprise category, and things that they could be thinking about now in order to help with the transition out of lockdown into what we look at as a new normal.
Absolutely. I think it was an incredibly difficult time for everybody, wasn't it? And it all happened so quickly that actually we've had to adapt very quickly, and maybe IP hasn't been top of the agenda while we've been adapting businesses very quickly and very seamlessly so we can try and react to this strange world that we're in.
Absolutely. And I think another thing that will be quite interesting and helpful in this discussion, I work out of our Aberdeen office, so the regulations for coming out of lockdown that I'm looking at are those that are being issued by the Scottish Government, whereas you're working in our Southampton office and presumably seeing a different set of lockdown easing notices coming out from the UK government, and that can be quite difficult for people to get their head around the differences, even just from different countries in our own United Kingdom.
Absolutely. And I think one of the hardest things, particularly relating to IP for this whole lockdown scenario, has been that every single country around the world has been reacting very differently in their interpretation of what lockdown is, how that affects businesses and what's needed from it. So obviously, you and I are working internationally with portfolios around the world, and every single intellectual property office pretty much has had a different reaction to it. So one of the headaches, even as an IP professional, let alone actually when you're an SME trying to manage these portfolios and keep a business going, has been trying to keep on top of what every jurisdiction is doing in terms of COVID and their response to it. And I'm sure you're the same. It's been a bit of a battle to try and keep up with it, and almost head-blowing every day that you've actually got a different response and a different set of deadline extensions and what have you. So I don't know about you, Wendy, but personally, I've been kind of thinking of it case by case rather than trying to think of it jurisdiction by jurisdiction, because otherwise there's too much to juggle.
I think that's a very good point. I think we've actually seen on a daily basis different patent offices around the world either extending deadlines or even applying different extensions to different types of deadlines. And then equally, it's very important for people to remember that as we come out of lockdown, different countries are coming out of lockdown at different rates and on different dates. So we're now starting to see a lot of these extensions coming to an end. Some countries have given us more notice that an extension is coming to an end, some haven't. So I would certainly be recommending to clients that they get in touch with their attorney as soon as possible, as quickly as possible, in order to ensure, particularly if they've been furloughed and unable to work during the recent lockdown procedure, that actually nothing in relation to their portfolio of cases has fallen out of sight or had any issues in relation to them. I know that we've all been in touch with our clients on a pretty much daily or weekly basis, but there will still be a lot of catching up for people to do, particularly if they've not been able to be in the office for, in some cases, up to about 3 months at any particular time.
And there's a lot to catch up on when you walk back into the office. So I think, yeah, totally, Wendy, it's we've been trying to keep up with actual deadlines if and where possible. But the important message to get across is that fortunately, dealing with intellectual property offices is that you're generally dealing with a human. So actually, everybody appreciates that this is an unusual circumstance, and where COVID has been affecting a business and has delayed things through furloughing or whatever is particular to that jurisdiction, actually having your attorney talk to the examiner, explain the situation, and actually examiners, they are humans. They do understand. So most IPOs are giving some kind of extension or some form of discussion to be able to keep rights alive. So I know you'll agree with me. The first message always with IP is don't panic. Actually talk to your attorney, take professional advice, talk to your attorney, let them talk to the director of the IPOs or whatever we need to do to establish what can be done. There's furloughing, but there's also things like if you're trying to submit a power of attorney that needs legalisation or anything like that, of course you can't do that in this kind of environment. Nobody's going to be panicking and saying that you've lost a right because of something like that. It's just about presenting the facts and explaining that despite all your best efforts, COVID really did mean that you couldn't meet the deadline if there isn't a mandatory extension of that deadline anyway.
And I think also, Rebecca, you touched on a very important thing there. It's preparing the evidence and explaining what happened. And I think that's a message that people should take away. First one, obviously, as you've said, don't panic. But the second, be able to explain what the issues were that meant that there was a problem in either meeting a deadline or getting something prepared. And patent offices around the world, as you say, are very aware of the issues. In fact, all the examiners themselves have typically been working from home and had to go through all the same issues that companies have. And they are very receptive to a well-reasoned explanation of what has led to a particular issue. So, if you can assist your attorney by providing that information in a very clear way, it makes it much easier for us to deal with the individual patent offices. And typically, we should get a reasonable result at the end of that because, like you say, they are very aware of what's been going on and everyone is trying to ensure that no one is disadvantaged purely on the basis of the COVID situation that has been ongoing in the world.
It's always about keeping that evidence. It's making sure that the facts are presented, and we've not had to deal with it so far, but I'm sure instances will arise where we are having to present that evidence and present it to the examiners, and I really don't see that they would have much standing to turn anything down. It's about keeping those rights alive and being reasonable in the circumstances.
Absolutely. I think that also leads on to something that was in my mind of thinking that would be very helpful for people, and that's as and when they can do, to make a plan to review their IP portfolios, because this has been a very uncertain time for businesses in the last few months. And having an IP portfolio, particularly as that IP portfolio grows, there are costs associated with it. And I think that there's a really good opportunity for people now to review their portfolio and look at what IP has been working for them and whether or not there are perhaps some areas that are less important. And particularly as a lot of people, I think, are going to be looking at IP budgets and trying to reassess what funds they have available. I think it's very important for people to identify their most important IP. And on a design side, that might be the shape of the particular product that is your bestseller and has been your bestseller historically, and you're expecting customers still to buy. Would that be the same in trademarks, Rebecca?
I think any chance like this, let's take some positive out of a negative situation that we've all been in for a long time now, and actually a chance to review those portfolios, look at your brands, check that you're using your marks as you have them registered, check that the specifications are accurate. And in many cases, obviously it's a good practice to be in, full stop, regardless of any strange global pandemic situations we find ourselves in. But also, particularly SMEs have had to be very quick and very adaptive. So are those designs that you've got registered correct for how you're using things now? Have you had to come up with a very quick, clever idea? Have you had to adapt it slightly? the trademark that you were using for drinks, when the drinks industry collapsed, when everything got closed down, you're now using it for something that's more of a ready-made variety. Check that you've actually got the right listings in your specification and the goods are correct. For example, with designs, maybe your design has had to be adapted so that there's less contact between parties and there's been a slight tweak in it. Well, that might change the way your design is presented, and it may mean that it needs a new application to get that protected. And whilst the old registration might still be relevant, you may also need to look at new applications to make sure that your IP is relevant and protected.
I think an important issue there, and particularly in relation to designs, is that many countries, including both the UK and EU, allow a grace period for filing a design application after you've publicised the design. So if your team have had to make changes to your designs and you've actually created new designs during this recent lockdown period, there may still be an opportunity to register those designs, even if they're out there in the public domain already. So that's a really important point for capturing things that your team have been doing at a time when nobody's working in a normal environment.
And also, yes, be conscious that clock has started ticking, because we all gasped when we all went into lockdown and it felt like eternity. But actually, we're 3 months in the UK. Time ticks past very quickly, and particularly when you're having to adapt, you're having to think on your feet, you're having to turn to the next project very quickly. You're not necessarily in the office, so it's actually an individual keeping track sometimes of when things started, when a project started, when that new version started coming into development. It's very easy to lose track.
Absolutely. And I think a top tip there, Rebecca, would be for companies to ensure that their teams get together as quickly as possible as they come out of lockdown, in order to make sure that they have a discussion over what new designs particularly, but also, what they have been working on. Because while we've all been working in our own home offices, we've lost the same face-to-face interaction with people where you often mention things. And online meetings are great, but you may have had an agenda for that and someone hasn't thought that that's the appropriate time to raise their hand and say, oh, actually, I've been working on this new product design or this new branding. So ensuring that you have a group discussion as quickly as possible coming out of lockdown, I think would be crucial to make sure that all of this new and very valuable IP that people will have been creating gets documented and captured, and a plan can be put in place in order to protect it as quickly as possible.
And it's very easy to forget that you had a quick email correspondence at 11 o'clock at night when you were talking to a new potential distributor in, I don't know, Brazil or something like that. And it's very easy to dismiss that, but actually that could be IP rights that we need to capture and actually utilise to commercialise that aspect quickly. And whether that's reviewing the design rights and making sure that protection's there if needed, making sure that new applications go in where necessary, or a licence agreement is put in place, or whatever it might be, that clock might be ticking. It might be a country where it's necessary that a licence is recorded, otherwise you can't enforce that licence. So yes, it's a very easy time to have very casual discussions that aren't actually noted down, as you say, because you're doing it on your own at home. And we're all human again. It slips your mind. You forget that you've just started talking to this person, and who knows where it might lead. But as you and I are well aware, once that clock starts ticking with IP, you need to keep on the ball and keep going. Make sure it's not an opportunity missed.
It's quite interesting that you talk about having those discussions, particularly late at night, in relation to different countries. I imagine for many companies coming out of lockdown, they may actually be having to look to different countries and different areas for their customer base going forward. This is an advantage, I think, that we have in relation to designs and trademarks, in that many countries still have local novelty requirements when it comes to registering IP in those countries. So it's really important, again, to speak to your advisors, because the fact that you have something registered in the UK, but now you're looking to a new customer base in China, for example, or in Brazil, as Rebecca, you mentioned, it may still be possible to register either the design or a trademark in those countries, where it might not be possible to register a new patent because the novelty requirements would be different. And I think that's something that everyone should really be looking at, to see if we're now having to find customers from different countries or even from different sectors, is there potential for expanding the IP that we already have in order to ensure that that works alongside the expansion of our customer base?
Completely. And I think some of these countries will be totally new to people in the firm. It could be an entirely new opportunity that's completely arisen out of COVID and the situation that we're in. And it's very important to remember that whilst you might be very experienced in IP in the UK and the EU and the US and Japan, every jurisdiction is different. So actually taking advice from your attorney, open the door to discussions. I know you'll totally agree with me that we would far, far rather that people came to us and asked and said the specific questions of, am I okay to use this in Australia? Are there any individual requirements that I need to consider? And actually take some advice, because yes, you may be entering a new jurisdiction, but it's not scary. We can put together a plan together. It's just about sharing the information and working on this to make sure that something good comes out of something negative.
And I think also that kind of leads on to, we said at the beginning that I think people should be looking to their IP portfolio and reviewing that regularly in any event, but particularly at the moment where it may be that the company is looking to raise additional financing, and ensuring that your IP portfolio is up to date and in the best possible state is always very helpful if you're looking at raising finance from investment, for example, or alternatively, if you're looking at divesting some of the IP portfolio that you have in order to focus on different aspects of the business. And I imagine particularly for a lot of our SMEs, their business coming out of lockdown may look entirely different from what it did going into lockdown. So it may be that there are opportunities to raise finance from part of your IP portfolio that previously you would never have looked at. I imagine that will be the same both in designs and trademarks, Rebecca.
Of course. It's one of the first lessons of IP, isn't it? They're an asset. They're an asset to be used. They're about making sure, as you say, whether it's seeking investment or actually selling them or licensing or whatever seems relevant at that point, there are ways of using IP. It doesn't have to be a static bit of your database that is put up into the proverbial attic and left there and dust blown off the lid when you need to. This is about it being alive and useful. And if it's not useful to you, well, then maybe exploring options of who this might be useful to, and using that either through not necessarily surrendering the ownership of it and selling it, but maybe licensing it, maybe some kind of commercial setup that wasn't apparent at the beginning of this that has come to the fore, and particularly relevant with designs because of the manufacture side of it, and actually whether there is a more realistic and beneficial relationship to be had that has become apparent.
Yes, and I guess also, situations like this quite often cause people to look at their IP portfolio in a slightly different way than they have in the past. Many people, I think, will shy away from enforcing IP because they think that it takes up a lot of time in the business and it can be an expensive thing to do. However, like you said, Rebecca, IP is a positive tool for business and something that can be used. And particularly if customers are going to be less numerous coming out of lockdown, I think everyone will want to ensure that their products are the ones that are being purchased and they are authentic products. So again, very important, if you do find someone who is selling counterfeit products or trying to muscle in on your market, now is a really good time to take a view on whether we can be sending a letter before action, for example, to draw attention to your IP, but making your IP work in a positive way for you is more important now than perhaps it ever has been before.
Yeah, I can't remember off the top of my head what the statistics are, but there are already statistics coming out on counterfeiting of it soaring at the moment, of people being opportunistic and taking advantage of what people perceive to be a likelihood of businesses being less proactive on their IP, and quite the contrary. Normally in an economic downturn, companies get hotter on their enforcing their IP rather than cooler. And yes, it might be more targeted, but the more obvious the counterfeiting, the more obvious the infringement of those rights, the far more likely they are to invest them. I think people really value that IP and can see that this investment that you've put into it over the years, now is a time for it to pay back. And that's both on a vigilance point of view, because obviously as IP attorneys, we can't be patrolling the borders. We're not aware of all the competitors of our clients, but with client input and their review and their knowledge of their own marketplace, we can help enforce this. And it doesn't necessarily have to be wildly expensive. A letter before action can be sufficient to deter some of this opportunistic counterfeiting, because that's exactly what it is at the moment. It's opportunistic. It's trying to make advantage of people not being on the ball, not observing, and it's a quick bit of money made here, and then they move on to the next person who's not been quite so quick to step in. So actually being observant, being on your toes, looking out for people trying to make a quick buck on what is your investment and your rights.
And I guess also in that, Rebecca, I think we have all, I know I personally have, we have all moved to a far more digital way of purchasing goods in the last 3 months. And I'm quite sure that there are many more people who are ordering goods online than there ever would have been before. And particularly in relation to authentic goods that have trademarks associated with them, I imagine that that's the counterfeiting of those types of goods is just going to increase exponentially given the situation that we've recently had.
We've already seen, so we have watch services in place for the vast majority of our clients. And actually the number of very, I would politely term them cheeky applications that are springing up around the world for some well-known, some less well-known brands that are blatant, absolute blatant copies of trademarks and being filed while they're hoping people's guards are down. So it's making sure, and obviously our job is to spot those, report them to the client, take action as and where necessary. But there is a very marked increase in, yes, as I say, I'm politely calling them cheeky, but the applications that really are a blatant infringement of either a well-known, not so well-known brand, but something, as you say, because the market is changing, they're hoping that because you're not walking into the physical retail side of the market has decreased, that they're taking this to just be a cheap, quick option for you to click on. And yet again, we're all human, Wendy. So actually, no, we all go for the quick, and if there's a bargain to be had, we're all after it. But just making sure that we keep an eye on that, on the Alibabas of this world and the eBays and the Amazons and all the rest of it. Because the good news, and I'm sure it's the same with designs, the good news is that those guys generally have a very good system now for taking down infringement of IP. So actually, it's not going to break the bank to step in and cut that channel for those counterfeit goods. And also customs notices can be really helpful. Things like that without necessarily having to be courtroom stuff. It can be a much more simple procedure, but it starts with being vigilant.
Absolutely, Rebecca. And funnily that you should mention these online sales platforms. I have worked very closely with a number of design clients in the past, and just in the last year had a number of competitor products taken off Amazon in particular. And they do have a robust, or certainly more robust now than it has been in the past. But there are channels that we can use in order to do that. And particularly if you do notice that there are online sellers that are popping up for these types of products, absolutely bring that to our attention. And the difficulty for consumers these days is that the try before you buy option of being in a shop has almost completely disappeared over the last 3 months. And even as that comes back, it will likely come back very slowly. And the number of people looking to continue buying online is probably likely to stay high, at least for the foreseeable time. So being extra vigilant if you see these types of counterfeit products or copycat products on sale, the quicker that we're aware of it, the quicker we can take action, and it is possible to get them taken down and off the site on the basis of IP that you have invested in and is registered. So absolutely, I think people should be looking to these types of things and alerting us as soon as they see something, because the longer you let it go on, the more difficult that can become. But also, the more sales revenue you're likely to lose on the basis of people buying that product at a time when more people are buying online than ever before.
Exactly, and particularly when it's vitally important. We're all trying to keep going in a different world, in a tight economy and all the rest of it. So actually stopping somebody riding on your coattails is a phrase that we always use in trademarks. Is very, very important. You shouldn't be delaying on taking action. And I think there's a common misconception for IP that it takes, if you're going to enforce something, it takes a lot of money, it takes a lot of effort, and there's no point, it's only for the big boys, it's only for the Pepsis of this world. And actually that's not true. It just requires a bit of being reactive. It's being open and watching and vigilant. It's being reactive when that does arise, and looking at the routes that don't mean tens of thousands and hundreds of thousands of pounds in court. It can just be, a couple of £1,000s, which is easily saved by stopping that revenue and stopping that stream. And as we said, it's quite frequently, they'll just be onto the least guarded option and move on from you and on to the next one. So we'd love to say that we can save the world into something like that, but actually just keeping the business going is our main concern at the moment. So as soon as anything like that is spotted, please contact us.
I think at this point, it might be helpful to just have a quick discussion around Brexit, particularly in relation to trademarks and designs, as we've just recently learned that the UK government has not asked for an extension of the transition period, and therefore the transitional provisions are due to come to an end on the 31st of December 2020. And Rebecca, if you could just summarise from a trademark perspective what that means people should be looking for, and I can then do the same on the design side.
So from a trademark perspective, it's if you have a registered trademark, on the 1st of January 2021, the UK IPO will issue a reciprocal UK right that's identical to your existing EU right. They'll be given a slightly different number. The main points on those that are registered in the reciprocal right is just to check that you haven't signed, for example, a coexistence agreement that said that you wouldn't use it in the UK, and therefore we will need to take active steps to make sure that reciprocal right is surrendered. So there may be some people for commercial reasons that require no UK right to be in existence. But that's a very, very minority of the cases. And if that applies to you, it will be ringing alarm bells already. So if you've recently come into the business and you're not quite sure, then ask your IP attorney or ask your colleagues to check the archives and check if there's any coexistence agreement that we should know about or license agreement in place that means that you should not have a UK right in your ownership. Beyond that, the main message from the IP world is if there is anything whatsoever you can do to make sure that any pending application is registered by the 31st of December, then all those avenues should be explored. So if it's currently in examination, if there's any way of speeding up responses to be able to get to the publication date as quickly as possible, because of course the opposition period in the EU is 3 months as opposed to 2 months with a possible extension in the UK. So we're already looking quite close to that timeline, because of course even once you're through that, you'll need to give a little bit of time for the admin process at the EU IPO to ensure that even though it's clear of the opposition period, that it's actually registered. Mustn't forget that it doesn't, as soon as it steps out of the opposition period, it isn't straight registered. There is a short period of time between that and the registration date. So making sure that you've speeded along to get through all of that and registered by the 31st of December, if possible. And of course, there's going to be some marks that are in opposition or they're in cancellation. That is still a bit of a grey area to be confirmed. But essentially, the way they are looking at it at the moment is there will be a period of time allowed for those pending cancellation and oppositions to be concluded. And again, the overall objective is that those that should rightfully have a UK reciprocal registration will receive that pending the outcome of that cancellation or opposition period. The final message would be that regardless of if you've got a pending application that isn't registered on the 31st of December, there is a 9-month period in which applicants can apply for a UK right and claim their EU application date. So it's a bit like the priority window that we're all used to dealing with trademarks of 6 months. This is just a 9-month period for you to be able to claim your EU application date for your corresponding UK right. It will incur fees, so it will effectively just basically be a new UK application, just with an amended application date. And I think designs are pretty much the same, Wendy, are they?
Pretty much, Rebecca. Anything that is already registered on the 1st of January 2021 will automatically have an equivalent UK registration created without anyone having to do anything for that. Anything that is still pending, similar to trademarks, we'll have a UK application and there will be a 9-month window that opens for people to file an equivalent design application in the UK, because the pending design application in the EU will no longer cover the UK. However, I think a significant difference that we have in relation to designs, and it's a huge advantage, is that the prosecution cycle for a design is very short. In fact, it can be as little as a matter of a few days. So between now and the end of the transition period, we still have a significant opportunity to have designs filed and registered at the EU. And because those rights will be registered as of the 1st of January 2021, it means that we'll get the benefit of the automatic UK registration being created when the UK has officially left the EU. And that's a significant cost saving for people, and something that I think anyone, particularly again, as we were talking about coming out of furlough now, there is a huge advantage in filing your design applications now in order to get those registrations granted before the transition period finally ends. And, there's absolutely no problem in doing that. I think if we're filing an application today on a design case, I would be expecting that to be registered within 1 or 2 weeks. So although we have significant time for it, I would expect there will be a large number of companies, particularly SMEs, looking at budgets for IP going into 2021, will be looking to file those applications now in order to get the benefit of the dual coverage. So my takeaway message there would be consider it and file your application sooner rather than later, so that you don't fall into a situation where the closer we get to the end of the transition period, the number of applications themselves are the things that slow down the prosecution cycle. So file the application sooner rather than later so that we get this significant benefit of dual coverage.
And it's very easy, isn't it? Because I know there's the common joke that we've lost the discussions over Brexit and replaced them with COVID. But it's very easy to think that, there's no point now, that there's no point thinking about EU registered rights because that's effectively old news and it's all done and dusted. The take-home message for designs particularly is it's very definitely not. It's now should be a crucial point to be reviewing that and making sure that if you've got a design that the EU is relevant for, get the application in, as you say, because there's likely to be a bit of a rush, and get the multi-jurisdictional benefits of an EU registration in place. But please don't think you've missed the boat.
Absolutely. And, I think the transition period coming to an end is really a green light in terms of ensuring that design protection is in place, filed and registered. And that's to the benefit of everyone looking forward in terms of their IP budgets. Particularly, for example, because once your design is registered, the first costing that you're going to be looking at is really in 5 years' time in paying a renewal fee. And now you'll be paying renewal fees both to the EU in respect of the EU part of the registration and separately to the UK for the standalone UK part of the same registration. So knowing that that cost is coming, but it's 5 years down the line, if you can avoid having to pay anything in relation to filing and prosecuting a design application in the UK, that's a big benefit, particularly at a time when people are finding their IP budgets are very stretched.
And as we've been saying, it's all about enforcement at the moment as well. It's about making sure that you use it. So actually making sure that you've got it in the first place is equally as important.
Yes, I mean, I think as we've touched on, this is a new normal that we're entering for IP particularly, but for SMEs in a wider context. And if we can take some of the pain in dealing with the IP side of things for them away, that's just going to be a lot easier going forward at a time when everything is competing to be the priority for businesses trying to get back up on their feet.
Absolutely. And I think as we return to the new normal, the other point to mention is that if some of this is urgent coming out of lockdown and your business has really changed, let us know and talk to us, because again, talking to an examiner, in some cases we can get prosecution expedited and move forward as quickly as possible. If we've got a launch date that's coming up, then let us know. You've got a launch date coming up and you've got a pending application that's been held up in the system because of COVID, let us know and we can talk to the examiners and see whether there's an opportunity to boost it up their priority list. They are not completely closed off to this idea. They are aware that people are having to adapt to this new normal, and sometimes that means trying to prioritise a pending application, and some examiners will be able to help out. So again, it's worth talking to us and keeping us in the loop to make sure that we can help where we can.
Absolutely. It's been great catching up with you, Rebecca, and really good chatting about all of this. I know my priority list, the number one on there is getting to a hairdresser. So I'm quite sure that our audience will have their own priorities on there, but I think it will be interesting to see how different companies manage this end of lockdown process, and hope to catch up with you back in an office again soon.
Absolutely, Wendy. I look forward to it when we've both visited hairdressers and we're not actually in our pyjamas while doing this recording.
Cheers and thanks.
Thank you, Wendy.
Our business is founded on trust and collaboration. The subjects we choose for our webinars are topical and informative. We are always looking for suggestions for new topics for discussion. So if there's an area of IP that you are keen to understand better, please drop us a line at webinar@murgitroyd.com.